Hi everyone, this is Shivani, and today we are going to learn about the doctrine of colourable legislation. Federalism is one of the fundamental important elements of Indian Constitution, and by the temperance of force, the Constitution visualizes an outline for government powers and functions between different constituent units of the country. Basically, in a federation, it is divided into different parts, and each part holds a different power and a different function. Indian framework is particularly affected to the colonial ruling arrangement of the English, and one of the impacts of this should be the strategy which made three different pillars of the democracy, which is the executive, the judiciary, and the legislature. In Indian direct partition of power succeeds by which a balance has been kept between various parts of or various organs of the government amongst which the law-making power basically rests with the legislature, the judicial power basically rests with the judiciary, and the execution of the legislative powers rests with the executive. The doctrine of colourable legislation means what cannot be done directly cannot also be done indirectly. The doctrine is applied when a legislation, while making a law in question, tries to accomplish something in a backhanded way when it cannot do it straightforwardly. In this manner, it eludes the ability of the legislature to establish a specific law. In the event that reproved enactment fails with the capacity of the legislature, the question of acting something indirectly which cannot be directly done emerges. What is the meaning and the scope and the applicability of this doctrine? The doctrine of calibrable legislation is derived from a Latin maxim which is quando aliquid prohibitor ex director prohibitor et per obliquum, that says what cannot be done directly should also not be done indirectly. This doctrine has been used in various cases to decide the questions or the capacity, the competency to enact a law when the lawmaking body, that is the legislature, violates its given powers and enacts something in an indirect way which it is barred from in, which is it is barred from acting in a direct way. The subject matter of the law appears to fall within the powers of the council on the face of the legislature. However, the connected impact or the motive behind the matter really falls past the authority and domain of the assembly. So, in a way, the doctrine limits the overstretching or abuse of the allowed established force in an undercover way. This is the reason the tenet is otherwise known as the fraud on constitution. The doctrine of colorable legislation is not applicable when SAL legislation does not fall under the legislative capacity of the legislature. What do we say? In one of the landmark cases, that is K.C. Ganpati Narayan Deo versus State of Orissa, it has been well explained. It has been explained in the case the scope of the doctrine. The court stated that if the constitution of the state distributes the legislative powers among different bodies, which have to act within their respective spheres marked out in the constitution in specific legislative entries, or if there are any limitations on the legislative authority in the shape of fundamental rights, the question arises whether the legislature in a particular case has or has not, in respect to a subject matter of the statute or in the method of enacting it, has transgressed or encroached the limits of the constitutional powers. Such transgressions may be patent, manifest, or direct, but it may also be disguised, covert, or indirect. And and to this latter class of cases that the expression colorable legislation has been applied in judicial pronouncements, which means something that is done in an indirect way is what colorable legislation pinpoints. Anything that is done that is prohibited from being done in a direct way is also prohibited from being done in an indirect way. Further, in this case, the Supreme Court also went on to opine and conveyed the idea that by the expression is that although apparently the legislature is passing a statute purported to act within the limits of these powers, yet in substance and reality it transgresses these powers. This transgression is mostly veiled by what appears on a proper examination to be mere pretense or guidance. If we say in other words, It is the substance of demonstration that material and simply would not structure the visible presentation. And if the topic in substance is above the powers of the legislation to enact upon the structure from where the law is stressed, it cannot save it from judgment. The legislature cannot abuse the constitutional privilege by attracting or applying indirect strategies. In the case of R.S. Joshi versus Ajit Mil, the Supreme Court observed and stated that the jurisprudence of the power of the colorable legislation or fraud on the legislative power or fraud on the constitution are expressions which mean that the legislature is incompetent to enact a particular law. Although the label of competency is struck on it, then if that label is struck, it turns into a colorable legislation. What is Let's go on to the historical background of colorable legislation. The development of the doctrine of colorable legislation, it goes back in the British time frame when the self-government had expanded its significance on the British Empire and the Commonwealth countries. The subjects of legislature then at the point were distributed within the central and the provincial units to keep in check of the powers. From that on, the doctrine discovered its approach in India that utilized the Canadian and Australian legislative points to take reference, to take on the standard of this doctrine. In India, this power of collectible legislation was later provided to the judiciary to apply this doctrine, while at the same time setting on the legislature the ability of the union and the state government bodies. The statement of Judge Aladi Krishnaswamy Iyer on the process of collegible legislation given in the Constituent Gathering is as follows. It is an accepted principle of constitutional law that when a legislature, be it the parliament at the center or a provincial legislature, is vested with the power to pass the law in regard to a particular subject matter under the provisions of the constitution, it is not for the court to sit in judgment over the act of the legislature. Of course, if the legislature is a colorable device, a contravene to outstep the limits of the legislative power or to use the language of a private law is a fraudulent exercise of power, the court may pronounce such a legislation to be invalid or ultra vires. Which means when a legislature makes a legislative law, it is not the duty of the court to keep a check on the legislative law. However, if it is shown or showcased that such a law is of colorable legislature, where such a law is made fraudulently or indirectly in a way in order to debar the or the disconduct the rights of the citizens given under the Constitution of India, then in such a case the court has the power to keep a check on the legislature before it such a law is executed in the country. Limitations of the applicability of this doctrine. There are certain impediments in the applicable of this doctrine. And what are those impediments? It is pertinent that in situation where the power of the legislation isn't strictly limited by the isn't constitution provisions, it doesn't reach out to the cases of subordinate legislation. The motive of the legislation by passing an order is superfluous to deter legitimacy. There will be consistently an assumption of constitutional legitimacy for the enactment of a legislature. The guideline was set down on Ramakrishna Dalia versus Justice R.S. Tendulkar and others. What are the guidelines? First of all, it can be distinguished as the fraud on constitution because we cannot violate a law through an indirect method. Colorability is bound with incompetency and not with an evil or bad motive. If the legislature has the power to make the laws, then the motive of in making the laws is irrelevant. If if something is colorable in appearance only, but not in reality, then the court looks into the true nature of the law, which is the pith and substance of the legislation, and in that case, focuses on the object as the purpose is relevant and not the motive. The expediency, necessity, and propriety of the legislation act are for the determination of legislative authority and not for the determination of the courts. If the legislature is competent to do a thing directly, then the fact that it is attempted to do it indirectly or in a disguised manner cannot make the respective act invalid. It only occurs when an act which is already governed cannot be done, it's already to be made, cannot be done indirectly or directly. Only that is the only case where if it is done indirectly, the doctrine of colorable legislation applies. So what have we learned from this? In conclusion, the Constitution disseminates the administrative forces between the Parliament and the state legislature, and each needs to act within its circle. In in regards to specific legislation, an inquiry might emerge whether the governing body has violated the law or not, violated the provisions imposed on it by the Constitution or not. Such offence may be patent, which is shown or directly. But however, if it is not shown directly, even then, if it is shown indirectly in some way or it is masked, then the doctrine of colorable legislation will apply. The locking of colorable legislation then comes to deal with an indirect violation of scenarios. This doctrine acts as a fundamental tool to keep an eye on the powers of legislatives granted to the union and the state government to decide the validity of the legislation in question or in doubt. Thank you.